Hi, everyone. This is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and welcome to Raw Law. This is the show where we answer your questions live and we talk about your comments. So let's get into it. I see we have a few comments already, and as we start answering, we'll probably get some more people in the room, get asking more questions. And, if we don't, we can go to the channel because we do get a lot of comments on the videos and we could, discuss that as well, the videos. So we have here a question from Virgo Vibes. And she says, why don't many lawyers show urgency or concern toward clients' circumstances, especially given severe injuries and financial strain? Clients really need help. Why we seek lawyers. Right, right. Well, I totally there's a sense of urgency. I don't know who represent plaintiffs. I mean, if they showed concern and they thought, well, you know what, we have to do this quickly. I see that my client is really injured. I don't know if that in and of itself is going to solve anything, right? Because the problem is not that the lawyer has to show concern. The problem is with the system. The system is just slow. So sometimes you file a lawsuit, you expect discovery to go, you expect depositions to go, you think I should have a trial date within a few months, but it takes years and years. Like today I did a video, wasn't posted yet. It was a video I recorded today on another case, a construction accident in New York. And so it took them 7 years to get to trial. And then they got a nice verdict, but then the judge knocked it down and cut it significantly. So then they had to appeal. And then the appeal took 6 years. So it's crazy. It's like 13 years. Then they finally got the verdict back, the original verdict that they won in the trial court. They got that back. So they got the money, but it took 13 years. So, I think the problem is just like the system. The system needs changing. But yeah, I mean, lawyers should definitely show more urgency or concern. I think one of the other issues may be because the lawyers are so busy and they get flooded with work and the insurance industry is so prevalent, and they kind of, dominate and they're like the gorilla in the room, right? The insurance, and they're like, so basically controlling everything. They have a lot of lobbies with the judges. So maybe the lawyers just get like overwhelmed. Instead of showing concern for their clients, they're just like, look, that's just the way it is. And they get mad and they almost get angry towards their clients, which isn't really good. And that doesn't really solve anything. And then the other question she had was, is it normal or okay that my lawyer got the footage of my accident from the grocery store 2 weeks ago? He said he has to figure out conversion so we can watch it. Shouldn't he know how to do that already? Well, I mean, conversion probably meaning if they sent you the CD, usually when they send the CD of the video or, however they send it, usually what they do is they give you the player. So you just have to click the player and then open the content of the video with the player that they give you. But if they didn't give him the player, then he might have to convert it to a different format. A lot of lawyers, they may not be audiovisual experts, so he might have to hire someone to do that. But yeah, usually it's not hard. All the CDs I've ever gotten, I've been able to watch. And if you can't watch it, you could also contact whoever gave it to you and say, hey, we can't watch this. So give me another copy or whatever. So it's just a technical issue. That should be easy to solve. Okay, and then Come Along with Uncle Joe says, hello. Hi, how are you? And Nene says, good afternoon, Arkady. What happens after a summary judgment is filed and how long does it take to hear back with the motion? Right. So usually if a party files a summary judgment motion, then the other side is going to oppose it and then it gets submitted to the judge. Sometimes the judge may say, I want oral argument in addition to the papers. So there's the papers, which are the affirmations and the exhibits, right? Because summary judgment is like a mini jury trial. It's like a summary trial. So you have to submit evidence in admissible form. So it could be affidavits, there could be photographs, there could be certified medical records. And then based on the review of everything, the judge will then decide either to grant summary judgment, which means that there are no questions of fact for a jury to decide at the time of trial. And so you get a judgment right now based on the papers. Or the judge could say, you know what, no, there are questions of fact, so that I can't decide this as a matter of law. and I have to give it to a jury, and then summary judgment is denied. How long it takes is usually just like a few months, depends on the judge and depends on how quickly it gets like briefed, right? Because somebody could file a motion, but then the other side could say, I need an adjournment until they file their opposition, and then there's a reply, and then everything gets submitted to the judge. That usually takes a few months, and then there might be a few more months for them to decide it. And then Anthony asks, good afternoon. Do you have to pay back Medicaid when you use your insurance on a claim? Yeah, I mean, you do have to pay back Medicaid if you have Medicaid, and if Medicaid paid for the injuries that were caused by the incident, right? So if you got, like, say, a trip and fall and you got injured because of the fall, and then Medicaid paid for that, then you have to, then they may have a lien. So they'll notify you. They'll say, we have a lien. And then you have to contact them, and either you can negotiate with them and lower it. Sometimes they waive it. There is no lien, but I'm pretty sure it's only for the amounts that Medicaid paid for the injuries that were caused by, let's say, the fall or the car crash or whatever the personal injury is, not for other things. I know Medicaid sometimes pays for like all your health care. So you have to get that like kind of itemized and almost like an investigation. So that's a little bit of work for the lawyer, but that's how they usually do it. And then Stomper says, Mr. Frekhtman, how long does it take for an insurance company to release their excess umbrella info upon request in New York City? In a rear end crash, a sedan is at fault and has $300,000 as a primary. Thanks. Yeah, so it doesn't really take long. I mean, really, they have to do it like automatically, right? So it's right in the preliminary conference orders now. It says that the defendant to provide insurance information, including primary and excess or umbrella. So you just have to, like, remind them if they don't give it to you automatically, just remind them. There's multiple sections of the CPLR, which is the Civil Practice Law and Rules. I believe one of them is 3101. There's a 3101 section that requires them. And then there might be like a 3122 section. I don't remember the numbers, but I have a letter. So the numbers are in the letter that I send. So usually when they don't give it, I just send the letter and then they give it after that. I've never really had to make a motion for it, but I mean, I suppose if they don't give you the excess. Now, what they do sometimes is they tell you, hey, there's no excess that we know about. So don't take that for an answer, right? Because there's no excess that we know about. So there could be excess, just we don't know about it. It's their job to find out, right? So then you say, look, tell me, aside from the primary of 300 that you already disclosed, is there any umbrella, excess, concurrent, supplemental, whatever you call it? Is there any other insurance that's applicable? And if they say not known at this time, just get affidavits from the insured, right? The policyholder, get affidavits from the broker, because the broker is the person who, sells the policy and procures or creates the policy. So they'll know. And then if you have affidavits of search, affidavits from the broker, just everything, you basically close off all the avenues for them to say, like, it might be there, but we're not going to tell you. You want to have a complete response. That's really, really critical. So you know how much insurance there is. But I really haven't had too many problems with that, at least in New York. And then Lion asks, hey, hope all is well. I had an ACDF surgery, C5, C6, 2 years ago. Now I have to get it all taken out and redone, plus segment 4. Will that increase my case value? Yes, absolutely. That's going to increase your case value significantly because, number one, now you have more injury, right? Because you have to have another surgery. So just like if you had just one surgery, let's say it's worth 1 million, but now you have 2 surgeries. So it could be worth like 1.5 or even 2 million. So that's one thing, which is the pain and suffering. Past, meaning from the date of the incident up until the trial, and then future, meaning from the date of the trial for the rest of your life. And people on average live to be like 83, 84 years. I don't know your age, but you're probably younger, so then you have a lot of future pain and suffering. So both categories get increased because of the second surgery. But the other thing you can do is then claim future medical costs because you've had this surgery that costs something, and that's known as an adjacent segment disease. So if you've had it 2 years ago at C5, C6, but now they have to do C4, usually it's 10 or 15 years, and at the adjacent or next level, you do need a surgery. And that's actually with a reasonable degree of medical probability, which is the legal standard. So if you have your doctor on this witness stand and he says, I swear to tell the truth, nothing but the truth, I'm the doctor, you say, well, to a reasonable degree of medical probability, will this patient need additional surgery in the future? And he's probably going to say yes because of the adjacent segment disease, because they're like articles from very reputable journals, and they all say that's to a reasonable degree of medical probability. If you have a fusion at one level, you need it at the next level below and the level above. So that's going to increase your medical costs, because just the fusion is like 100,000 plus with inflation. And, and it's not just the fusion. You're going to need MRIs, you're going to need physical therapy, you're going to need prescriptions. So all the medical costs are going to go up. I think I've said before that I had a case with a gentleman who was like 58 and he had one level fusion at L5, S1 in his lower back. And just his medical costs were like 2.8 million. So imagine having two. Now it's going to be maybe 3 something million. It's going to be different, depending on your doctor and depending on your economist, but definitely, plead that. So you have future medical costs, but then you also have pain and suffering. So you have both. So it's going to increase tremendously. Okay. And then a car 1994 says, I had a trip and fall at my apartment complex that has lots of holes everywhere. They never took care of the parking lot. I ended up having torn ligaments. Will the lawyer pursue the threat of punitive damages? Punitive damages, probably not, unless they did something. Punitive damages are more like if somebody knows that what they're doing is likely to cause harm and they could stop it, right? But they do it anyway. And they say, we don't care. Like, we're going to burn someone, but, we don't care. Just let's burn them because it's cheaper to pay them like a small settlement, like $10,000. Because we think probably we're just going to burn them a little bit, so we'll just pay them $10,000, but let's burn them anyway because, kind of profits over safety. If you have something like that, like really egregious, really disgusting and terrible and like against public policy, but just having holes in an apartment complex, and a lot of apartment complexes have holes. They might just, happen with potholes. It could be like snowing, the weather, people get holes, the ceilings collapse. All those cases are not punitive cases. Punitives are pretty rare. There have been findings of punitives in some states. In New York, it's very hard to get punitives. Usually they're not included. But so that would not be punitives. But you don't really need punitives if they have a hole. You fell because of the hole. You have an injury. You just get money for your pain and suffering. You get money for your medical costs. You get money for your lost wages. There's enough, categories where you can get money, and all you have to prove is that they were not a reasonable landlord, right? A reasonable landlord would take care of it. And you have to prove notice. Hey, you should have known about this hole. This hole existed, let's say, a year before. So you had a year to fix it. You made the choice not to fix it. You put people in harm's way, right? You were unsafe. That's all you have to prove, and then you win. So you don't really need punitives. And then Daniel says, hello. Hi, how are you? And Vinod says, hello. Hi. And Faro says, what happens when there's complications in your back, cortisone injection? Can you go above your policy limit from 65 to 130? Depending on the complication, we'd have to know what the injury is, like the actual medical diagnosis. It's possible, but you can't really go higher. Like if all they have is like 65, then it's hard to get more than they have. Now, the only way you can get more than they have is if you do like a bad faith letter, basically saying, hey, you have a $65,000 policy, pay me the 65. And, I know that's all you have. And if you don't pay within 30 days, then it's not going to be 65 anymore. It's going to be 130. But then if I go to the jury trial and the jury gives me 130, how are you going to pay it? Because all you have is 65. So then I'm going to make an argument that your insurance company is liable for the whole judgment because the policy is now open. And you have to write like a very comprehensive letter. Like when I send these letters, they're like 15, 20 pages, and there's a lot of different elements you have to put in them. And then it'll also depend on the law of each state, because some states have strong like bad faith law where you can open up policies, but other states don't. Like New York doesn't really have bad faith law. So it's pretty hard. I still write the letters. I still get success with settlements sometimes, but it's not really as strong as it would be somewhere else where like California, Oregon, Texas, I think has bad faith law, Florida. I know Seattle, Washington State has really good bad faith law. So you'd have to be somewhere like that probably to do better with bad faith. And then George asks, is the arbitrator, if the arbitrator is from the same association and the defense team does he have to remove himself, or how does that work here in Texas? Oh, you mean like the same law firm as the defense? Then yeah, he would have to probably remove himself because he couldn't be impartial. He's with the same firm. So that would be a conflict of interest. Yeah, you'd want an independent arbitrator if you're doing arbitration. And then Virgo asks, my apartment complex has no handicap accommodations. They said because it's conventional housing, they aren't required to accommodate disabled tenants. They said if I need accommodations, I'd have to pay for them myself. Oh, really? I'm not sure about that. I mean, I know there's the American ADA, right? The American with Disabilities Act, and I think that's federal. So you might want to ask like a local lawyer about that. I'm not too sure about that because that's not really my field. I'm more of like the personal injury lawyer. But if they're not giving you accommodations and you want the accommodations, you might want to look into that ADA claim because I'm pretty sure that's federal. Yeah. And then Stomper says, what if I have many different injuries and cannot entirely remember every detail at the deposition? Wouldn't the defense attorney suspect a plaintiff who remembers every detail of their case? I mean, just be reasonable. If you don't remember anything, that's not good, right? What they're really doing is they're like evaluating you, right? They're kind of evaluating what kind of witness you would be at trial. So if you show up there, like sometimes they even evaluate someone's appearance, right? The way someone shows up. They say, hey, this guy showed up in a tank top and he's got all these tattoos. So then they're thinking, okay, maybe the jury's not going to like this person. They're going to think this person is like some kind of, I don't know, bad person, thug, criminal, whatever, right? It's just kind of like stereotypes. And then what they also evaluate is how you answer the question. So if you answer the questions nicely, right, and you're polite and you're pleasant, they're going to say, oh, he would make a good appearance in front of a jury. But if you answer like by arguing or, not answering certain things, they're going to say, well, he will make a bad appearance. And then they could use your answers at deposition. They could then read them and then impeach you with them at trial. So if you say something a little different, they could say, wait a minute, but like 2 years ago when you had your deposition, didn't you say, and they'll read from the transcript, right? So then it's kind of like, is that correct what you said 2 years ago? Or is this correct what you're saying at trial? So you have to be consistent, right? But in terms of like not remembering details, it just depends on what you're talking about. Now, if you have a lot of different injuries, you're not expected to know all the medical diagnoses. If you have, for example, like a broken arm, and also a neck injury and also a leg injury, you could say I had a broken arm, I had a leg, torn meniscus. If you don't know, you could just say I had surgery for my knee. If they say, well, what was the surgery for? I said, I don't know. The doctor knows the medical diagnosis. That's fine. You don't have to know. You're not a doctor. So it's really, depending on you, whatever level of comfort you get to, either by speaking to your lawyer, being prepared, looking at the medical records. But usually what they ask you is like what doctors you went to, what the doctors did for you. So for example, if you went to a doctor, they're going to say, well, why did you go to that doctor? What was hurting? Okay, my knee. Or what did the doctor do for you? Well, he examined me. He gave me a shot. Then he scheduled me for surgery. That's the kind of questions they ask. They're not going to really ask you like every, medical diagnosis. Of course, you wouldn't know every medical diagnosis. It gets a little complicated. That's why the doctors will also testify. They'll talk about that. So I wouldn't really worry about that. Okay, and then Vinod asks, what would you do if your bills are $1 million and you're settling for $1 million? Under the lawyer's pressure, do you think anyone can change the lawyer during mediation process? Well, I mean, if your bills are $1 million, your medical bills are that high, probably what you'd want to do is you'd want to get a lot more than $1 million, right? It would be low to settle for $1 million. And then you'd want to get an assurance from the lawyer. Well, even though the bills are $1 million, can you lower these bills? Give me it in writing, right? I lower them to like 100,000. Because look, if you settle for $1 million, the lawyer's taking 300, right? So now you have 700. Now, if your bills are $1 million, and they're going to take the 700, then you get nothing. So what's the point, right? You say, look, I have to get the lion's share. It's my case. It's my injury. I have to live with this for the rest of my life. So you have to make sure before you sign anything that they then have to lower, the bills or be able to settle the bills for like 100,000, 200,000, even though they're $1 million, right? Because, or get more, get 2 million, get 3 million. So that's usually how that's done. And in terms of changing lawyers, I mean, it's possible. It just depends on whether another lawyer would accept the case. So it depends on what the issues with the case are. Like, why are they only giving, if the bills are $1 million, usually they should be offering a lot more than $1 million, right? Like 3, 4, whatever. But why are they only offering $1 million? Is it because they're just being cheap right now and then you should go to trial and get more? Or is it because the case has some issues like causation or something else where, it's just not a strong case? So there could be both, right? It just depends. So what I would, what you could do is you could speak to some other lawyers and see if they're interested in taking the case. You could text me 347-566-9595. I could give you some lawyers in your state, and then they could look at the case and they could tell you. Sometimes people say, yes, I'll take it. Sometimes people say, no, I won't take it. Sometimes people say, today I had a case where the lawyer said, I forget which state this was, but the lawyer said, I'll take it. I love this case. And then later that day, he emails me. He goes, well, after speaking with the client and getting the full details, I don't want this case. So you never know. But you can't really control that. But what I try to do is I try to find like the best lawyer for the client. So it might take some time, because sometimes what I'll do is I'll give them like a really good lawyer, right? But the really good lawyers, they want really good cases. They want like the $100 million cases. So they don't take very much, right? Because not every case is a $100 million case. So then you have to go to the next level, right? The lawyer with the $10 million case, then the next level lawyer with the $1 million, until you find the lawyer that's right for you. But I always like to start with the best and work my way down, but it might take a little time. But, you never know what other lawyers are going to do. Sometimes like one lawyer will say, no, I don't want this case, but another lawyer will say, yes, I love this kind of case. So it's just kind of like, have to shop it around, I guess, if you're looking for someone new. And then Sandy says, had my deposition today. I did yes or no answers, very concise. I was polite, and my attorney was very pleased. I have so much treatment racked up and a $300,000 limit. Likelihood of policy limit settlement. Yeah, I mean, congratulations. That's good that you did your deposition, that it went well. The attorney was pleased. Those are all good things. I mean, it just depends on other factors. I don't know what the injuries are, right? We'd have to know what the injuries are. If the injuries are significant, like what city you're in, how the case is going. I guess now your lawyer is going to depose the defendant, put it on the trial calendar. So I think, if your injuries are serious, then I think it's 300 could be easily taken, and it depends on how they negotiate it, right? If they say, hey, pay me the 300, if you don't, then it's going to be like 600. And then what are you going to do if we do get 600 from a jury? Who's going to pay? I'm going to hold you responsible if your state has bad faith, if you put pressure on the insurance company. So it depends on all these things, right? Like how the lawyer does the settlement, how they prepare for trial, what the injuries are. All these things play a role. So we'd have to do more of like an analysis. But you could text me 347-566-9595. I'm happy to do a consultation. We could discuss and see if it makes sense, that it's 300 or more. And then Massey says, after 2 years, my insurer still has not offered a settlement. Would it be bad if I tell my lawyer to request them to close the claim with a settlement? So you're saying the insurance company that the defendant has not offered you a settlement? Because your insurer would be like your, if you have a policy, like your insurer, like it'll be like you're the policyholder. I think you mean the defendant, right? Whoever you're suing is not offering you a settlement. And would it be bad if you tell your lawyer to request them to close the claim with a settlement? But what does that mean, close the claim? I mean, sure, you could request them. The reason there's not a settlement is because they're probably not offering you enough money. You can't just request them to close the claim with a settlement. They could just say no. And then, unless you want anything, right? You could just say, well, give me anything. Okay, I'll give you $1,000. Okay, I'll close it. Oh, you're saying my own insurer, my own accident benefits insurer. I'm not sure. It depends on the type of case this is. I'm not really sure what kind of case this is. So I can't really advise you. But if it's your own, what kind of settlement are you trying to get from your own? Like a UM or something, an uninsured motorist? I mean, your lawyer should just negotiate with them. If they're not giving you enough, you could do an arbitration, and then the arbitrator will set the amount if you're not happy with, the settlement that they're giving you. But you can't just request them to close. You know what I mean? There's no such thing. You just call them, you give them all the medical records, you say, hey, let's settle. Either they give you nothing, then you know, hey, I have to go to the trial or arbitration, or they give you something, but it's not enough, like pennies on the dollar. Then you say, hey, wait, this is pennies on the dollar. I don't want it. But if, unless you just want anything, then you can take anything, of course, you know. And then Stomper said, I tend to get emotional when recalling the sequence of events since the crash. Now, if I'm crying at my deposition, would I be looked at as a fool? Something remarkable may happen. Not okay to fake, by the way. No, I'm sorry to hear that. Of course, if it's a serious crash and it's like a very, you know, life-changing and you have severe injuries, I mean, sometimes people do get emotional and cry, and that happens, and they take a break. And, you know, sometimes if you think it's going to be like really powerful, and you could record the deposition and then you have the video of it to show, hey, this is real. This isn't, I'm not faking. And he says, sorry about the weird question, sir. I was crying since the moment of the crash because of the excruciating pain. I really don't want to be looked at as a whiner. It's a real pain and sorrow. What do I do? No, I mean, of course, I understand. I'm sorry to hear that. I mean, what I would do is just do your best, you know, try to relax, listen to the question, answer the question calmly, you know, and then do preparations with your attorney. Make sure your lawyer, in a serious case like that with a deposition coming up, you should be prepared, you know, 4 times, at least 3 times. And if your deposition, let's say, is, you know, 3 weeks away, you want to schedule 2 or 3 preparations before the deposition so that you can get like your reps in, you know, basically like all the questions, all the answers, have your list, go over the outlines, practice answering it. So then when you are in the deposition, you've already done this, right? It's easy. Because otherwise it's going to be hard. You've never done it before. You don't want to be thrown in there with like a bunch of wolf defense lawyers like attacking you. That could be very scary and very, you know, unfair. So make sure your lawyer prepares you, like with a big case, I think 2 or 3 times. Then it's kind of like you've gone through all the, kind of like, you know, if you're playing a game, right? You're like an NFL team. They play a game on Sunday. They don't just show up to the game. They practice, right? They practice Monday. They practice Tuesday. It's the same thing. You got to practice, and then you're ready for the show, for the deposition. And then George says, sorry, last question. Could my attorney use similar arbitration awards from other cases to help mine in any way? Yeah, absolutely. Of course. Yeah, that's what they should do. If they've already had similar awards, you show that, and that's evidence. That's called a precedent, right? Because it's already happened. That's very helpful. And then Israel says, hi, Arkady. I hope all is well. I hope you have a great rest of your stream, and thanks for taking the time to share your knowledge with us. Oh, thank you so much. I really appreciate that. And James says, what should I expect? Atherosclerosis, my deposition. What should you expect? I'm not sure what the question is. In your deposition, if you have that condition, or I'd have to get a clarification on the questions. It's a little bit, see if I don't think you wrote anything before, right? No, I think that's the first question. Yeah, I probably need a clarification. Atherosclerosis, I believe, is like an issue with the heart, right? Where you have like plaque buildup. Is that what it is? I'm not sure, but I think that's what it is. Deposition is when they ask you questions and you have a deposition, or unless you're talking about like a medical malpractice case that involves atherosclerosis. So I need a little clarification on that one. And then Virgo says, I have cerebral palsy, so how can the footage of my trip and fall be dissected? I have different body makeup and movements than the average person. Oh, I see. So yeah, that's fine. I mean, you know, you don't have to be like, basically you look at the footage, and then you might, I don't know if your lawyer is going to get like a human factors expert to say, or somebody, but the doctor could talk about it too. The doctor could look at the footage at trial or at deposition, and the doctor could say, yeah, this patient has, you know, cerebral palsy. So this is consistent. This is like what a person with cerebral palsy would, how they would move. It's reasonable. It's normal. And then it really depends on, you know, that like, unless you did something crazy, right? You did something in the video that shows, hey, you were at fault, like you jumped, or you know, but if you're just moving slowly, I think this is the case where you said you took a step back and you hit the beer, right? The beer was stacked improperly. So that sounds like a good case, because, you know, they have to, when they have a store like that, they know that they're going to have different people come to the store, right? Some are going to be like little kids, like 3-year-olds. Some are going to be really old, like 89, 90 years old, really frail, maybe with a wheelchair or with a walker. Some are going to be people with, developmental disabilities, whether it's cerebral palsy or someone else, right? It's all different people, all different ages, all different abilities. So they have to, keep the store safe for everybody. It's not just safe for like, a really like a ballerina who could like dance around everything, right? Or a running back who's like really, really agile. It's safe for everybody because you have all different types of people. So that's one of the points that your lawyer has to make. And then Stomper says, great advice. Your heart is in the right place. Oh, thank you so much. I appreciate that. And James says, I'm sorry, what should I expect after my deposition? Oh, okay. So in terms of the process after the deposition, your lawyer then takes the deposition of the defendants. That's part of discovery. Documents get exchanged. Then you put the case on the trial calendar. You get settlement conferences, mediations. If the case does not settle, then you're going to have a trial date. That's going to be like further down the road. So that's usually how the procedure goes. And then David says, does multi-level degenerative disc disease of the spine affect the case value? My first MRI didn't show I had it before. So yeah, disc disease you don't want to show. It's not really, because disc disease is not from a crash, right? If it's degenerative and the doctors agree it's degenerative, that's like the normal painless aging process. So degeneration happens naturally. Even if you didn't have a crash, you would get degeneration through age, through living your life. It's the normal painless aging process. So that's actually the defendant's argument. They're going to want to say, hey, this is not traumatic. This is not from the crash. This is just degenerative. And so you have to show if something is degenerative, right? If your doctor agrees it's degenerative, just leave it out. Don't claim that. And whatever else is not degenerative and is traumatic, that's what you claim. Because degeneration, is the normal painless aging process. It's not traumatic. So it can't be caused by the accident. Now, what you could have is you could have degeneration, right? Because however old you are, let's say you're 40 years old, right? So you have the spine of a 40-year-old. So when they find degeneration, of course they do, right? Because you're not a baby, you're not 1, you're not 2, you're 40. Of course they're going to find degeneration. That's natural. But what did the trauma, the car crash, do to make the degeneration worse? So that's what you have to show. So it's not a matter of saying it's degenerative. It's a matter of showing, well, yeah, I have degeneration. It was pre-existing because I have the spine of a 40-year-old because I'm 40. I'm not going to have the spine of a 2-year-old because I'm not 2. But how did this crash add the trauma on top of the degeneration to then make it even worse? You see, that's what you have to show. And the doctors usually are pretty good about that. They know that. The radiologists, the pain management doctors, the orthopedists. So that's what you have to hit on. And then Virgo says, I'm worried they'll convince a jury that my disability is to blame for my trip and fall despite their aisle obstruction. Thank you. Well, I mean, it's not really you could be worried, but like, why would you be worried about that? Like, how did the disability specifically cause you to trip and fall, right? If like the aisle obstruction didn't play a role, let's say like you're standing, right? And the aisle obstruction is like 2 feet away. And then all of a sudden you have like a disability related medical event, like a seizure, and you just fall. Well, obviously the obstruction didn't cause anything. So it's like 2-3 feet away. You didn't trip over it. That would be, it's an impossible case. But if you were walking or you're stepping back and you hit the obstruction and the video shows it's the obstruction that played a substantial factor in causing the fall and then therefore the injury, right? Then you're good. So I don't really, it's not a matter of being worried. It's just a matter of, it's either one or two, right? It either caused it or it didn't cause it. So I would just make all the arguments that you can, make the case as strong as possible, see if you can get like a strong trial lawyer on the case, and you should be fine. Okay. Or give me 1 second. I'll be right back. Oh, okay. I'm back. Sorry about that. So let's see. So what were we up to? I think we're up to George. He asks, how true is this younger work victim get higher arbitration awards? I mean, like if you're younger, depends on what the case is about, right? If you're younger, of course, if it's a serious injury, you are going to have higher pain and suffering because it's going to be longer, right? You have more of a lifespan. And if you have, let's say, lost wages, you're going to have more, right? Because let's say you're 20 and then you could be working till like 65. So you have 45 years of wage loss. So if you're making like $100,000 a year times 45 years was like 4.5 million, right? It's huge. Plus with inflation. So you have that. But it really depends on the type of case. So with lost wages, sure, if you're younger and then you're making serious wages, it's going to be more because you have more of a loss. But if it's just like pain and suffering, you could also make the counter argument, well, somebody who's in their golden years, let's say they're already like 70, 80, they don't have anything else, right? This is it. So if you hurt them at that time and you take their golden years away, then that's all they've got, right? And it's their golden years, and then you've taken everything from them. So it's worth more than if you hurt somebody in their 20s, they can get better and now they're fine, and then they live the rest of their life healthy. So it just depends on the type of case. And then Sandy says, my attorney prepped me this morning 1 hour before my deposition. I had already done extensive research on depositions and prepared myself, but is this normal? I mean, yeah, I would say it is pretty normal. That's what most attorneys do. It's not really good, though. I don't really like it. I think if it's a serious case, I mean, it depends on the case. Look, if it's a small case, sure. But if it's a big case, what the best thing to do is to prepare, when the deposition will be, right? It's scheduled. So there's no reason to only prepare once the day of, right before. What I like to do is prepare at least 3 or 4 times. And this is like, I've been to a lot of continuing legal educations, like out in, I did one with this lady. She works with the Trial Lawyers College, which was like the Jerry Spence School. I think her name is Catherine James. And she was saying like 3 or 4 preps. And she wrote a book, actually, Harvesting Witnesses' Stories and how to, be very persuasive, how to prepare, how to testify. And I think she said 3 or 4 times. And a lot of people say 3 or 4 times because the first time is really just to sit down with the witness and just to say, well, what are you worried about? Like, tell me. And just have them tell you what they're worried about, what they're afraid of, right? Just to get them comfortable, maybe answer their questions about how everything works. Then the second time you have to go through all the questions and all the answers and then how to deal with questions, how to relax, how to understand what they're asking, how to answer it properly. And that's a lot of information because you're talking about liability. Sometimes cases get complex with like experts, right? How to prove who was at fault. There's also perception time, right? Where were they looking before they stepped? What was in their hands, right? You have to go through all that, right? Like liability. But then you also have to go through damages, meaning how did this affect you? What were all the medical treatments that you went to? You maybe want to create a timeline so they know basically on the timeline, all the doctors they went to, why did they go to them? What did the doctor do for them? Who recommended them to all these doctors, right? And then not just that, but then you also have to go through because if it's a serious life-changing case, you also have to talk about, well, then what was the effect on your life? So you have to then talk about your life a little bit, your biography, your like human story, right? How did it affect your marriage, your kids, your friends, your work life, your passions, what you love to do. So all that's a lot of work, right? And then what I like to do is I have that list that I've sent to some people. It's like a 13-page list where it has a lot of activities, and then people could check off some activities. And it has things like, how do you spend Thanksgiving? Or do you like to sew? Or some people like to surf, right? It has a lot of different activities, but it's not just that. It's also like, by reading that 13-page list, you might then get a trigger like, oh yeah, that happened. And then it's like a moment in time. And that could be either before you had your incident or it could be after. And then you go to that moment in time and then you tell a story, right, about what happened. Or you could just talk about a moment in time. So then all those little things get put into the, you want to throw those into the answers when you testify. So it's a lot of work, really, if you want to do it the right way. I don't think you could just prep once this morning for an hour. And I mean, that'll be a very that's the way everybody does it basically. But if you want to be like better, if you want to get like, regular results, like, people settle cases for 10,000, but then other people settle cases for 10 million, right? So if you want to do a really good job, I think it's better to do more preps. And then Burnt says, should you worry if the defense keeps adding admitted witness lists? So this is, you mean witnesses to what though? What would the witnesses, it depends on what the witnesses saw or what the witnesses will testify to. I mean, are you talking about liability? Like the witnesses will show that you were at fault or that the defendant was not at fault, or I'm not really sure. Like, it depends on what the witnesses will say, but just adding witnesses, I mean, I wouldn't by itself isn't really, I mean, that's what everyone does, right? They have their witnesses, you have your witnesses. So, and then Stomper says, from your experience, how negotiable are funding liens? For instance, if the case settles for $200,000 and the client owes $70,000 in funding, what do you do after you take your well-deserved share? Or must the plaintiff almost always accept what it is and take whatever is left for them since it was their choice to take funds out? Yeah, so with funding, you can contact them and then they do reduce. I mean, it depends on the company. Some companies will reduce substantially. Some companies will cap, right? So for example, if they gave you like 10, they'll cap at 20 or 30. You don't want 10 to turn into 70, right? Because that's like 7x. That's kind of crazy. So, but if they do, you could say, look, I can't have it at 70. I need it at like 50. They can work with you. Some companies might not, because they say, look, it's not up to us. That's what the client signed the contract. If the case was lost, we would get nothing, right? So we took that risk, but now the case was successful for 200K and we have investors. We have to pay our investors back. And they don't, I mean, they'll still go down a little, but they won't go down too much. So it just depends on you and your lawyer. If you want to agree with them, you could agree. If you want to like take them to court, have the judge decide, you could do that. If you want to negotiate with them, you could do that. But I like to always make sure that fundings are capped, so they can't go crazy and charge you crazy interest. And then Krabby says, always worth a visit to this channel. Oh, thank you so much. And then JRM says, how often do depositions get canceled because the defendant wants more medical records? And is that a good thing? Yeah, I mean, I've seen that. Basically, if they don't have all the medical records, they don't want to take your deposition. They want to get everything and then depose you at once, right? Because if they, well, otherwise they would depose you, do the deposition, but then get additional records. So now they would say, well, what about all these records? I have questions about this. And now they have to bring you back. And that's more inconvenience for you to get deposed twice, especially if the records already exist. Right now, if you're going to have a surgery in the future, well, then yeah, that makes sense because you haven't had it yet. There are no records. But if the records already exist, then it's probably better to wait, especially if it's quick, because getting records is pretty quick. It's usually about a few days to a few weeks. And then Chippy Bear says, love your videos. Thank you for teaching us about the law and your experience, I think you mean, right? Oh, thank you so much. I appreciate that. And Krabby also asks, what would you suggest if, for example, a nurse or doctor has a personal bias against you and purposely omits or includes things in your chart that are detrimental to your case? Well, I mean, if you feel like the nurse is biased against you, you could tell your lawyer, and maybe the lawyer could make a motion in limine to exclude the records. Or a lot of the times the records are not going to come in, especially the nurse. You can call the nurse to testify and then cross-examine the nurse and ask, hey, do you have a bias? Or, expose the bias, show the bias, whatever it is on the stand. But a lot of the times the nurses aren't going to be the ones testifying. It's going to be the doctors. So the doctor could then, as long as the doctor doesn't have any issues, they could be impartial. You should be fine. And then Burns says for trial, the witnesses for trial, and it's mainly about billing. Okay. Yeah, I'm not sure though, like, because it's not really. I'm not really sure like what you're asking. You're saying should you worry, but like if they just have witnesses, why would you? I mean, everybody has witnesses. If they didn't have witnesses, it would be weird, right? Because then how would they would have nobody. So then you would definitely win, right? Because you would have your doctors. If it's an injury case, you would have your whatever experts. You would have you would have your friends, whoever's your witnesses. the defendants, they're going to have their witnesses too. So that's pretty standard, and they have to probably add them to the list, because if you don't add them to the list, if you don't exchange them, you can't just bring them in, right? You can't just say, hey, I have all these witnesses, here they are. It doesn't work that way, right? They're going to say, surprise, that's like trial by ambush. So you have to exchange the witnesses. So that's pretty standard operating procedure. And then Big Max, Krabby says, thank you, or you're very welcome. And Miss B says, I'm still waiting on you to do a trial search on CRPS cases in the Dallas, Texas area and surrounding states. Yeah, I'll definitely do that. I apologize. Yeah, I've been a little busy. I've been away, and then I had a few other. Now I have a trial coming up in beginning of November, so I've been prepping for the trial. But I think I could do that. I hope maybe even this week I'll try to do that. I did one video earlier today on a case, on a construction case, so I could probably do some CRPS. I didn't get around to doing the verdict searches because they're kind of like very like substantive, when you get into the verdict search, like so much information. So it's kind of hard to do a video about it, because either you have to like study it and then somehow, shorten it to make it more digestible and easy, or you just have to kind of like do the video as you're digesting it, as you're reading it. But then it gets like a little, I guess I could do both, or try both and see which one works better. In the past, I've just kind of been doing them at the same time as the video, almost like a live. So, I could do it. It's a lot of information. So, but yeah, I'll take a look near Texas for CRPS. And Big Mac says, do you find insurance companies don't offer their best offer until mediation occurs? That's when they authorize more money. Not really. It could be, right? What you have to do is you have to make them pay. So basically, like, tell them what you want. Like, say, I want $1 million. You have 30 days. Pay me the $1 million. If you don't, that's fine. But guess what? It's not going to be $1 million anymore. It's going to be 3. And then boom. And then it's up to them. Now, see, they don't like that, because either they have to pay you the $1 million, or they have to pay you close, or have to pay you $850. Maybe you'll take it, right? Or they have to not pay you like $20,000, or say, we don't have any offer. Great. Now it's 3. And then you have to stick to your guns. And if you really believe that, but it has to be the right case. The case has to really be worth like 3, or have the potential to be 3 from a jury. Then you kind of like stick them in the corner, because what they want to do is they want to do the opposite, right? They want to like make you ask for less, right? They want you to demand money, like beg them, right? So they're going to say, we have $1 million. What's your demand? If you say 950, they're going to say, oh, you're crazy. 950. All we have is $1 million. Are you crazy? No, you have to demand like 100. Then if you demand 100, maybe I can get you 50. You see what but if you do that, if you demand 100, well, guess what? 900 just walked out the door. You just gave him a $900,000 gift. Do you like giving people $900,000 gifts? No, right? So that's the way they operate. So you have to know how insurance companies operate. And just because they agree to do a mediation, what I've said as many times, what they like to do is agree to do the mediation just so they could dishearten you and tell you how bad your case is, and basically like lowball you, give you pennies on the dollar. So I don't even agree to mediations unless they give me a good faith offer first to show me that the mediation is going to prove fruitful, right? That it's going to lead to something. Then I'll go to the mediation. But why am I going to go to a mediation just because they want a mediation? It's just what they want to do is just they want to lowball you and make you upset. And then you're going to say to your lawyer, why did you bring me here? For them to tell me how bad my case is, and I thought I was getting $1 million. They're giving me 5,000. What is this, right? And then you're going to get upset, and then it leads to a lot of problems. That's what they like to do. It's kind of like their game plan. So you have to be careful with that. And then Vinod asks, what would happen if you and the lawyer and all the other lien holders not at the same table? Do you have the right not to settle and go to trial with a new lawyer? Yeah, you could go to trial. You don't have to settle. Why do you have to settle? A mediation is just like an offer. They give you an offer. If you don't like the offer, you say, no, thank you. You just go to trial. And then Sandy says, if the policy limit is 300 and my med bills are at 110,000 before reduction, and the insurance doesn't pay the 300, tries to pay less, is it worth it to just go to trial? Anything under 3 is way too low. Well, yeah, if your med bills, then you have to pay them. They're 110. So even if you settle for 300, you figure the lawyer's going to take 100. Now you have 200 left, but you have to pay 100 out of the 200, or more than half, right? 110. So you want to get those bills lowered, see if you get them lowered to like 50 or something, if you have to pay them back, right? Because that's, so yeah, anything under 300 is really low. Even 300 is low. So yeah, you have to be careful with that. And then Stomper says, I lost the energy I used to have, and my daughter was a small baby when I got life-altering injuries. Never got to find out what it's like to be fully healthy while enjoying quality time with a newborn. None of it is my fault. No, I'm really sorry. Yeah, that's exactly like the type of thing that you want to be able to explain, right? Through a story or through a moment in time, or, in the deposition or at the trial, because that's the kind of thing where the jurors, if they're listening to the case, they're going to say, wait a minute, this, I see now, this is a serious life-changing forever injury, because they have daughters, they have sons, and they're going to like think of their children, and they're going to show, wait, this is not one of these little frivolous cases where somebody's money hungry. This is a real case. We have to give this person like substantial financial justice, right, to make them whole. So that's what you want to show in order to get like maximum damages and to get good results. So that's exactly the kind of thing where you want to be a little bit like emotional, but you want to also be factual and show evidence. So you have everything, right? Kind of like Plato, right? He said there's like the three components. There's logic, and then there's emotion, and then there's also, I forget the third one, but but basically logic, evidence, emotion. That's what you want to show, as much of that as you can. That's going to be persuasive. That's going to help you win. And then Big Mac says, have you ever had success lowering or negotiating down ERISA medical bills? Laws are different for company-funded medical plans. I don't usually negotiate that stuff myself. I usually just do the trials. So we have somebody who does it, like an office manager. I could ask, I could find out. I mean, I think we have negotiated some of those, but yeah, you're right. Like if it's company-funded medical plan, then I believe they can have a lien. But if it's not company funded, if it's just a health insurance, you don't even have to pay that back at all. So, that's not a lien. So yeah, but ERISA, I believe, is a lien. So, and there's laws around that. So yeah, I'm not, I don't really negotiate those myself, but yeah, I mean, you could still negotiate them down. I mean, basically they want a piece of the pie, right? Because they paid out money. And whatever, the settlement's $1 million, the lawyer's taking 300, you're getting 700, but they might have a lien for like whatever, 100. So they want their 100K, they want their piece of the pie. So you just talk to them and say, look, but I can't give you 100K because it's too much. So you give them like 70K, or they'll come down, usually we have a lot of success negotiating things down. And then Jose says, if the policy is 500 to $1 million, 500 per person, is that the limit one person can get? I'm more injured than my passenger. Yeah, exactly. If it's not, it's 500 over $1 million. So yeah, the most, if that's how it's written, then yeah, 500 over $1 million would be like 500 per person. That's the most any one person can get. And the entire crash, there's $1 million for the entire crash. So say there's 20 people in the car, right? They all have to split the $1 million. But yeah, if you have two people, then you can get up to 500 each, or you can get 500 and the other person, if they're not injured, might only get like 50 or whatever. But yeah, that is exactly how it works. Okay. Let me see if we have any other questions. If not, I guess we could wrap it up. We've been going for about an hour, so that's good. And we're going to do a few more. I did one today, like I said, on a construction case. And we may do another one about like, let me know what videos you guys want to see. I can do one about depositions, about the legal process, how everything works. I'm going to try to add a little bit more fresh content to the channel, maybe day in the life of a lawyer, right? What it's like to be a lawyer, what we have to do in terms of like trial prep. And then I've have a few cases I can talk about, 2 success stories. Like we recently settled a nice case for like 1.2 million. So we could do that. Maybe I'll do it together with another attorney in my office because she helped settle that case. So we could talk about that case. This was a car crash case. Also, we got like lowballed, but we just stuck to our guns. It was actually in a very conservative venue. People were saying, oh, up here, we don't give that kind of money. We give like 20,000. I said, no. And we stuck to our guns, and we got like, I think we're close to 1.2, almost the entire policy. Oh, and Big Mac asks, have you written any books? No, I haven't, but I should probably maybe write a book. Or I know there are a bunch of law sites where people write books, like trial guides and other other organizations, and I actually know a bunch of people that write books, and I've kind of learned from them and helped a little bit or worked with them. So maybe it's time to like write one. I have to just come up with an interesting topic. And then a car says, thank you. I've done 36 physical therapy sessions, 3 stem cell injections, and 3 hospital visits. The medical bills are $105,000 and lost wages are $18,000. Happened in Las Vegas. Any ideas what the case is worth? Well, I mean, was it a car crash? I mean, stem cell injections, that's pretty serious. Physical therapy is serious. Hospital visits. If the medical bills are 105, that's pretty serious. I mean, so it could be worth like $500,000. It could be worth more. I don't like, some lawyers like to take the medical bills and say, well, the settlement should be 3 times the medical bills. I don't really like that. I like to just say, look, what is the injury? What's the diagnosis? Is it a surgery? Is it a herniated disc? What's the impact to your life? There should be like a little bit of a deep dive into your human story or biography. How has it impacted you? And if the answer is that, it's a permanent life-changing injury, well, then you have to have permanent life-changing money to compensate you for that, right? So that could be you could have 100,000 in medical bills and have a $10 million case if the injury is serious enough and there's enough insurance. And actually in Vegas, I know a lot of excellent attorneys. I'm handling a few cases in Vegas. I'm actually going to be going out there for a conference, maybe at the end of September, beginning of October as well. They're doing like a jury ball conference with focus groups where they talk about, how to focus group your case. So basically, when you have a case, you could show it to groups of people, like, 100 people, 1,000 people, see what they say, and then use that information. Because guess what? When you go to trial, you're going to get, like in New York, it's just 6 people. Those 6 people are going to decide. So wouldn't you want to then first shop it to, like, say, 100 people, get their opinions, get their analysis, and then use that information to then at your trial when you have 6 people, right? In other states, you might have 12 people. And when you do it with a large amount of people, what happens is you could almost nail it. Like these guys are nailing it. They're basically saying, this case, I'm going to ask for, or I'm going to tell the jury that civil justice is 19 million. And then they say, hey, 19 million. And then they come back and they get 19.5 million. It's almost like exact, because they know based on speaking to like hundreds, if not thousands of people, what everyone's going to say, right? So that's really brilliant. So I want to go and learn more about that method. It's a little expensive, but on the bigger cases, it makes sense to do it. And we're like working on a few cases together as well. And then Krabby says, do you think that treatment for lower back pain known as radiofrequency ablation or radiofrequency denervation is a serious treatment and warrants the higher end of compensation? I had 3 done in my lower back. I was rear-ended by a commercial vehicle and the policy is 1 million. It sure felt serious, and I'll definitely never be back to 100%. Yeah, I mean, those are worth money. Definitely. Those are pain management procedures. I mean, I've had cases with pain management go for like, I haven't had too many just with that denervation, but I think what they're doing is essentially, because the nerve is being impacted by the herniated disc or the bulging disc, what they're doing is they're like burning the nerve. They're denervating it so that, you still have the bulge is still coming out or the herniation is still coming out of the disc. It's touching the nerve, but you're just not feeling the pain because they're burning the nerve. That's a serious procedure. Yeah, that could be worth a few $100,000, I think. I've had the other one, the percutaneous discectomy, and I've settled out those from 300. Even we had one. We had a verdict actually just like a week or 2 ago for 300 on that, and we had another one for like 548 a few years ago. So those could be serious. And then a car says it's a grade 3 ankle sprain, 95% MMI, still wake up with aches and stiffness 5 months later, aggravation of my migraines. It was a trip and fall at an apartment complex. I'm 30. Yeah, so that could definitely be serious. That could definitely be serious. Trip and fall, as long as they have liability, they were at fault. Grade 3 ankle sprain. And yeah, that could be significant. Just make sure you have like a good trial lawyer. Because, I don't like those billboard lawyers because they never go to court. All they do is pick up the phone, whatever number they get offered, they just take it. And because they don't go to court, so they don't have any ability to get you more money. So it's like if the insurance company wants to give you $5K, they're just going to say $5K, and they don't care because they have the billboard, so they just get more cases. So it's like a mill. It's like they're just making money, but at your expense. So you don't want that. Okay, and then Machine says, will multiple herniated discs receive a bigger settlement than one herniated disc? Yeah, of course, right? Because if you have more injuries, as long as it's caused by the crash, you're going to get more money. So yeah, of course. Okay, everyone, I got to run, but thank you. Please like, subscribe to our channel. We are here for you. Our goal is helping serious injury victims and families. Let us know what videos you want to see. Let us know what questions you have, and we'll do another live maybe later this week. Okay, have a great night, everyone. Stay safe.